Okay, I see 7:02. So I think we're going to go ahead and get going. Welcome, everybody, to our fifth town hall for the Tort Claimants Committee. My name is John Humphrey. I'm the chairman of the Tort Claimants Committee. I'm accompanied by Doug Kennedy, the vice chairman, Jim Stang, our lead counsel, and John Lucas. And you have, if this is your first time, this is going to be a little bit new to you. If you have been with us before, welcome back. You know the drill. I'm going to give you some of the ground rules. We'll try to keep it to under an hour. We have an email address that you can always reference, and that is BSA TCC at pszjlaw.com. Sorry, sometimes I get that one. Also, BSA survivors at PSZJ Law. I'd like to remind you that we are taking questions, but you're only going to see the ones that we respond to. We collect the rest of them. We know some of you would like to passionately express your feelings on a particular topic, and so we will take those. Also, if you choose to be anonymous, submit your question as an anonymous question, because when we do respond to it in the chat, you will see that. So other things, we're not here to provide legal advice. This is purely informational. We are on the fifth town hall, and I'm really excited about getting going because there's lots of information to communicate. First thing I would say is what we're going to cover mostly tonight is the disclosure statement. I have a couple comments that I'd just like to lead. I mean, I know Doug's spoken before, but you know, a long time ago, I worked for a company that had an office in San Francisco, and this was really before Starbucks became famous. And I go down in the lobby to get a cup of coffee, and I'm in this long line, and I hear all this chatter about decaf this and latte, vanilla, whatever. And I'm standing behind this person, and they order a double decaf, fat-free, skinny, no foam latte. And I'm cracking up because this is not my vernacular at all. And I go up to the guy after she takes her drink, and I said, "What's that called?" And he points up to the board, and it's called Why Bother? That was the name of the drink. And I have to tell you that that's kind of my feeling on this this plan that's been filed by the BSA, and Jim and John are going to go through a lot of details. There's some high level things that I'll just throw out as a matter of fact. I mean, lack of detailed information on the BSA assets, a lack of participation by the local councils, and complete lack of transparency. You know, they are doing the turtle defense, and they're putting their heads inside, and they're really not participating at all. A totally unacceptable offer by Hartford, billions below what they are liable for. No basis in fact on any of the other offers. When you look at the Archdiocese, the recent USC offering, Michigan State, these guys are just like in complete and total deniability. You know, the fact that the BSA has overfunded their pension by substantial amounts of money, and this voting that they want to do, which is by a master ballot. So these are just a few things that I think we're going to discuss tonight. The other thing that I'll bring to your attention is the insurers recently filed an objection against the legal fees that have been run up. And I'm sure you all read that. There was an article in the New York Times about that. So first of all, you know, they purported that we should all hold back 20% of our fees. Our attorneys readily agreed. And, you know, when you look at the total amount of fees that have been charged so far, I believe the TCC's professionals are less than 10 or 11% of that total. So we went out and we hired the very best people we could find. They're doing a great job. We review every bill, every page, every hour. And I can tell you that our fees are reasonable. And there's been no state court counsel or survivor or anybody else in this case that has received a dime. So I just want to make sure that that's clear. Anyway, with that, I'd like to turn it over to Doug to talk a little bit about an FAQ that we put up on attorney representation. Doug?
Thanks, John. I appreciate it. I couldn't agree more with what you had to say about the fees and the incredible work that our professionals are doing. You also mentioned the questions and how we try and get to as many of them as we can, but it's really important that everybody knows that one of the things that we do is that we look at all the questions after these town halls. We try and see if there are some themes that emerge and some things that we can address. And one of those has been a number of questions about, do I need an attorney? If the TCC has an attorney, why would I have to go get an attorney? So what we did was we sat down and with the work of our professionals, we put together an FAQ that's contained on the tccbsa.com website. So if you go there, you'll see this FAQ. And on it, we address issues like, am I required to have an attorney? The answer to that question is no. By the laws of the bankruptcy, all the bankruptcy rules, you do not have to have an attorney to file a claim. However, there's another important question, that is, should I have an attorney? And the TCC recommends that you do. Again, you don't have to, but this is very, very complicated. It's probably going to get more complicated before it's over. So we also address issues like, where do I find an attorney? And a number of people ask questions about, where can I get an attorney? So we've included a link in there to the bar associations for all the states, which is good one-stop shopping to start to narrow that down a little bit. Other questions like, how much will an attorney cost? I filed a claim in bankruptcy. Do I also have a claim against the local council or chartering organization? So we've addressed a number of the questions related to whether or not you need an attorney for your personal lawsuit against the Boy Scouts or any other organization. So if you still have those questions, we hope that you'll go to the website and check out the FAQ. And again, all this information, as well as previous meetings and any other file that we've talked about, you can find at tccbsa.com. So that's my message for tonight. Hope everybody's hanging in there. Back to you, John.
Thanks, Doug. And before I turn it over to Jim and John, just a reminder that if we do type an answer to an anonymous question, no one will know your name. If you're worried about somebody knowing what your question is, use anonymous. Otherwise, we're collecting all of those. Already have some really good questions. So with that, I'd like to turn it over to Jim Stang and John Lucas. Gentlemen.
Thank you, John. I just want, my name is Jim Stang. The other gentleman wearing the tie is John Lucas, my partner. I just want to address the fee issue for a moment. When our firm was interviewed and selected to be counsel to the committee, Doug and John sat me down and said, we want you to be reasonable about your fees. And without hesitation, I said, we are going to contribute 10% of our collections to the settlement trust whenever that is established, essentially the fund for survivors. We did not increase our fees by 10% before I made that offer. And so what's happening is, on a quarterly basis, when we get paid, we take 10% of what we've collected of fees, not out-of-pocket costs, and we put that in a client trust account, and it's sitting in our accounting system in a separate bank account. And when a settlement trust is created, that money will be released and delivered. So I wanted people to know that. Last week, there was a mediation in New York. To step back for a moment, there are 3 mediators appointed by the Bankruptcy Court. One is an insurance specialist. The second is a retired bankruptcy judge from Delaware, which is where this case is situated. So he has some insights into what the judges there are likely to do or won't do. And third, a gentleman who has probably mediated more Boy Scout claims than anyone else in the country. And they act as a panel with, as you can tell, certain specialties, and they are the mediators. So when we say we're in mediation, we work with them and when discussing things with the parties opposite, be it local councils, BSA, or the insurance companies. This was the second. There have been lots of mediation sessions over the course of the case, but they've all been by Zoom. But there have been 2 that have been hybrid, meaning you could go in person or you could attend by Zoom. And with COVID, that's the arrangement so people can feel safe. The first one was in Miami, which feels like it was about a month ago, maybe 6 weeks ago. And the most recent one was in New York within the last 2 weeks. And we attended in person and by Zoom at that meeting. It was 3 days. It was productive in the sense that people are getting, even at this late stage, a better understanding of each other's positions. But no deals were reached. No monetary agreements were reached. Offers were made. Counter offers were not provided, but I would say crystallizing issues did occur. One of the things that has been made very clear to BSA and to the local councils and to their insurance companies, the coalition and the TCC are working together. Every effort's being made to coordinate strategy, to coordinate the terms of a plan of reorganization that we think survivors should support, and to agree on the dollars involved. We don't always agree, but we are working together very closely on a number of issues. And several pleadings have been filed over the last, I would say 60 days, that were joint pleadings. The moving parties were the TCC, the coalition, and a person called the future claims representative. And so it's important that we demonstrate to BSA and the councils and the chartered organizations and the insurers that we are acting as one, and it gives us more power and the greater likelihood for a beneficial outcome for survivors. So that was New York. Next steps after New York, nothing has been scheduled for an in-person meeting, but there are every day discussions going on with the people that have authority to further try to drive towards a resolution. It may be a global resolution where everyone who has responsibility for the abuse you suffered has made their contribution, and that would be proposed to you in a plan. Or it might be parts where BSA settles, but the local councils are still out there. And I saw a question about what happens if they don't participate. We'll talk more about that. It might be some insurance companies, but not all of them. So we are trying to be very nimble to ensure that we get you the best values. So I'm going to have to step out of the picture for just a moment. John, back to you. Or should I just keep going?
No, you can keep going.
Okay, so where are we at the moment? The Boy Scouts of America has filed a plan and disclosure statement. It is the second amended plan and disclosure statement. They filed one on the day they filed bankruptcy. It was a placeholder. It was essentially a shell. They filed a first amended plan and disclosure statement that made some monetary offers and had a basic outline of how they wanted to reorganize. And then they filed a second one, which had a lot more detail in it. The disclosure statement is a document that the court must review and approve before the reorganization plan can go out to you for you to consider. Now, if you want to see it, it's available on the Omni management site. But it's not there for you to vote on, because the first step is to ensure that you get a statement that gives you enough information so you can make an informed vote. Now, the disclosure statement that they filed, I actually went and weighed it. It weighs 2 pounds. And there's a lot in there. But honestly, there's a lot that's not in there. And so the process that's going on now is parties who feel more information is needed are objecting to the adequacy of the disclosure statement. So you have a disclosure statement. It is the proposed disclosure statement. It was written by BSA, and different parties have filed objections to it, saying what's wrong with it, what information needs to be added, and also explaining to the court why the BSA reorganization plan is, in the words of one party, dead on arrival. So how many people have responded to the disclosure statement? We filed an extensive objection that is available at the website that John has gave you the address on. The coalition filed an objection. The Future Claims Rep filed an objection. The Girl Scouts of America filed an objection. I'm not going to list everyone by name. This is just the highlights. And the Justice Department, through the Office of the United States Trustee, filed an objection. And these objections say, in effect, you haven't given people enough information. 10 insurance companies filed objections. 73 law firms on behalf of 10,000 survivors filed objections. 73 law firms on behalf of 10,000 claimants filed objections. 4 chartered organizations filed objections. I know the Mormons did. I think the Methodists did. I don't know who the other 2 are off the top of my head. Over 300 letters have been sent to Judge Silverstein by survivors explaining the impact of the abuse and asking her to make sure the Boy Scouts do the right thing. Our disclosure statement objection is on the website. You can read it. One of the 2 very important things are in our objection, and it kind of relates to these letters. The letters that are going into Judge Silverstein are directly from survivors. They are not letters from lawyers to the judge. That's why lawyers file pleadings. And for every letter that comes in, Judge Silverstein is sealing it, which means you can't see the letter at all. That's version 1. And then version 2 is a redaction of the letter, which takes out the name of the sender and identifying individuals. And also, I think she's taking out things that she feels are very graphic. Some people actually wrote across the top of their letters, "Do not redact." But she's in control of her docket, and she can put up there, in terms of redactions, whatever she likes. But it was very important to the Tort Claimants Committee members for her and the public to see some information about the abuse you suffered. Now, obviously, it's representative. No one can speak for you as individuals in the sense of what you experienced and how it's affected you. But the members of the Tort Claimants Committee can do that. And so several put their personal bits of their personal story at the very beginning of the disclosure statement objection. So if you do look at it, it's very long. If you read it through, you're running a marathon. But it might be interesting to those of you that aren't prepared to go through our 70-page objection to see how we've portrayed the survivor experience as understood by Tort Claimant Committee members. And I thought it was very compelling. And that's not redacted, folks. That's there for everyone to read. The other part of our objection that I think is interesting, and I understand is causing some heads to shake, is an exhibit. We have a financial advisor, Berkeley Research Group. You've heard us talk about them. In fact, I think Matt Babcock for BRG actually attended one of these town hall meetings and spoke to all of you. We have done an in-depth financial analysis of every local council. People think I'm being a little smart ass when I say I think we know more about them than they know about themselves. It is, John will correct me, at least 15 or 20 pages on each local council, ranging from an analysis of the claims that are against them, the cash and investments they have, the real estate they have identified by camp, the camps that they don't need because of underutilization, their membership trends, their operating expenses, our assessment of how much cash they need to have on hand to continue performing the scouting mission. It's all in an exhibit as an exemplar for one local council. Now that local council's name is redacted, but it shows you, and it shows, more importantly, shows them what we know about the local councils. We are probably on Monday going to start rolling out to each local council their own analysis. We refer to them as dashboards. And each local council is going to get its dashboard. And we are hoping that the people who manage the local councils and advise the scout executives will review those dashboards, will assess what can really be done to address their responsibility for survivor abuse. So if I had to say there's two standout things about our objection, it's the testimony by certain of the tort claimant committee members, and it's a demonstration that we have a very detailed understanding of the local council assets and liabilities.
Hey, Jim, before you go on, let me just add some color to that. You know, folks, it's a long document. In fact, the BSA's plan was so lacking, we had to actually petition the court to use more pages in our response. And it's not hard to read, and it's in English, and you can see just the total lack of attention to detail and the total lack of information. There's simply not enough information in this thing for any of us to make an informed decision. And I would say that to the local councils, you know, we do not want scouting to end. I know that there are some of you out there that are hurt and you are indifferent to that. That is not our goal. Our goal is to get and maximize the claims and the dollars that we get for survivors. And we believe that the local councils have substantial assets that they can make available to survivors. And the detail that we provided, as Jim said, is thorough. So I think it would do you good to read it. It's the crux of our argument.
Right. I want to just build on that for a moment. Every analysis that we did, which includes a proposed contribution of money and camps to a settlement fund, is premised first on that each local council will keep 2 years of operating money. We know how much it costs to operate your local council. We have all of that financial information. So we didn't zero out the bank accounts. 2 years of operating money, and whatever else you raise, or I should say the local councils raise by donations or otherwise, is in addition to that. So there's that buffer we put in there. It underscores what John just said. These proposals do not seek to liquidate local councils. The other thing we did was we looked at camp utilization. There are innumerable reports coming from BSA and individual local councils that the camps are underutilized. So we mapped out the location of every camp in the country, every scout store in the country, and we drew a circle around each camp to see what other camps were nearby. What was the utilization of those camps? Because frankly, while we hear every camp is essential, if you take away a single camp, it'll destroy our local council. The fact of the matter is, in lots of parts of the country, there are so many camps so close to one another that if you are efficiently using them, there's probably about 40% or 50% of the camps that you could dispose of and not affect a kid's ability to go camping. So that's what these dashboards show. And again, we're hoping that it will break some log jams in what we're having in negotiations with the local councils. The other objections, oh, by the way, we worked closely, very closely, with the 73 law firms that filed that represent 10,000 claimants in their disclosure statement objections. This was an effort to make sure that the court wasn't inundated with duplicative pleadings, because the last thing she needs to read is, I don't know how many we had altogether, close to 100 objections. And so we were trying to be very targeted about what issues would be raised by who. So that's where we are on the disclosure statement. The hearing on the disclosure statement is May 19th, and the court has scheduled an overflow hearing for May 24th. There are a lot of other issues that the court has before her besides the approval of the disclosure statement. I think we'll see how far she gets. I don't know that she'll complete the work by the 24th. And as I think it was John said, the Boy Scouts are filing another plan and disclosure statement Sunday evening. And presumably it will build upon what they already have. Hopefully it will improve the disclosure statement to narrow the differences on its adequacy, but we'll see. Once the disclosure statement has been approved by the court, if she decides to approve it, the plan and the disclosure statement and other accompanying materials will be sent out to creditors and survivors so you can vote. And John Lucas, if you could chat for a few minutes about what that process looks like in terms of who's getting the plan and disclosure statement and what people need to do to ensure that they're part of that process.
Yeah, so, I sent a link. Somebody asked a question about where I could find the disclosure statement and the plan. And in response to that question, I posted an answer to a link to the Omni website, which has a button, if you will, to review the court docket. And on the court docket, you could just type in disclosure statement and the link there will pop up. Type of plan of reorganization and the link will pop up. Probably have a couple of choices. But that's
John, if I could just volunteer, there's actually a button for plan documents. You don't have to go into the docket itself. I think there's a button that says plan documents. It'll be easier to search.
Yeah.
Sorry, but talk about how do I know, how am I going to get my plan and disclosure statement? Does my lawyer get my plan and disclosure statement? Can you just chat about that for a moment?
Can you say that again, Jim? I didn't hear what you said.
How do people know whether they're going to get their plan and disclosure statement delivered to the house? Is it going to go to their lawyer? How do they know who's going to actually get this materials if the court approves the disclosure statement and sends the plan out for a vote?
Yes. So here, I'll start this way first. If you are acting alone and without an attorney, which means you filed a proof of claim yourself, and you have the address and contact information on your proof of claim, the plan and disclosure statement and the other materials that go along with it will be mailed to the contact information on your proof of claim. If your proof of claim includes an attorney and you check the box that says you may contact my attorney, then all of the solicitation materials will be sent to the attorney, and you should contact your attorney to get all the materials because they will not be sent to you.
And,
Okay.
and isn't it true that in a lot of ways, our objections is the beginning of a negotiation, and a plan that may or may not get approved might be completely different than what was filed already by the BSA.
We're hoping it's completely different.
I'm just trying to set expectations that we
Right.
could be in this process of updating and negotiating and changing for some time to come.
This is an ongoing, folks, it's happening every day. It's very fluid, and that's why we want to have these meetings periodically to keep you advised. And if we get into some tighter schedules and we need to have one more frequently than once a month, we will do that. Okay, so I think we've covered the plan and the disclosure statement process. I will just add this last bit. In the package of materials that John was just referring to, John Lucas, there will be letters of recommendation as to how the parties feel you should vote. There'll be one from Boy Scouts of America. In their current proposal to the court, you only get to put a letter into the envelope if you support the plan. We obviously think that's a little too one-sided. And one of our objections to the court is that the Tort Claimants Committee, as the fiduciary representative of all survivors, should have the ability to put its letter in. Might be a letter of recommendation, but it might be a letter to vote yes, but it might be a recommendation to vote no. Likewise, I believe the coalition has asked for permission to put its recommendation in as well. So those materials will have that kind of cover transmittal. But if you're represented by counsel, absolutely contact your attorney so that you understand how you should vote, how you should vote. And if the attorney is voting for you, very clear direction is how you want the attorney to vote.
So Jim, we saw the BSA got a big splash in the newspaper, and Hartford reported in its quarterly financials about this purported settlement that they did with the BSA. Can you comment on that?
Sure. Just as the TCC and the coalition have uniformly said, we do not support this plan, both the TCC and the coalition have said, we do not support the Hartford settlement. Hartford is one of the two largest insurance carriers with the largest insurance risk in the case. And the BSA negotiated a settlement with Hartford by which Hartford pays $650 million on account of no less than 24,000 claims. And it, in effect, tears up the insurance policy in exchange for $650 million. There is an adjustment to that $650 million, depending on what another insurance company does. It's a company called Century. So this is a little complicated, but I'll try to say it simply. The benchmark for Century is $1.3 billion. If Century pays less than that amount, the Hartford settlement goes down. So let's assume there's no agreement with Century, folks. This is just a benchmark that Hartford and the Boy Scouts established. So if Century were to pay $1 billion, half of the difference, 300 million is the difference, half of that is 150. The Hartford settlement goes down from 650 to 500. Half of the difference between 1.3 and what Century pays reduces the Hartford number. We have no idea how much Century will pay. I mean, I guess theoretically it could pay zero, which means Hartford pays zero. But that's the Hartford settlement. It has to be approved by the Bankruptcy Court. It is likely to be part of the amended plan that we expect to see Sunday night. We're just not sure. We haven't seen drafts. But that number is a big number. $650 million is a lot of money. But take out your calculators and divide it by 24,000, which, by the way, is at least the number of Hartford claimants, meaning claims that fall in the Hartford insurance years. It is probably a greater number because many, many survivors, this is the old thing you've heard from us before, did not put the dates of their abuse in the claim form, at least not in the computer fields which asked for it. And so it's at least 24,000. And I don't know the number off the top of my head, but it's not a lot per person on average. So that's the Hartford deal. And as I said, is the subject, it will be opposed by the coalition. It will be opposed by us. And I think any other creditor representative that I've been in touch with, or that John Lucas has been in touch with, intends to oppose it. If it doesn't get approved, Hartford's on the risk. Hartford has exposure, which can be realized, if you will, make them pay in lots of different ways. But that's what the Hartford settlement is.
Did we have a local counsel presentation a week or so ago?
Yes. So as part of, John, I'm just going to stop for a moment. John, are there any other insurance questions or disclosure statement questions that you want to interject with now, or should I keep going with local counsels?
No, I think I've answered some. There's quite a few questions, and I've responding back and trying to answer quite a bunch. So I'm sort of scrolling through and sort of trying to go back to the earlier ones. I think we should just continue to move on, and I'll jump in when I think I need to.
Okay.
And let me just say one thing. I'll let Jim catch his breath for a second. And John and I are both responding to some messages. I'm trying to send some messages to people directly. But one of the themes I'm seeing that I'd like, maybe John, maybe you'd be the person to respond to this, is a number of people are saying, why don't we just liquidate the Boy Scouts? You know, with what they did to us, how could we ever consider that they should continue? You know, why don't we just go ahead and just clear them out and take every dollar we can? And that's a question that, quite frankly, the TCC talked about very early on when it met. And there's some reasons why, for the good of survivors now, we have to take a very sort of, I think what Jim said one time, agnostic view of the future of the BSA. John, could you just address that for a second? John Lucas, maybe?
So I think there's a couple ways to sort of look at this. The first of all is if the Boy Scouts themselves just decided just to pull the plug and just to liquidate everything, I think that there's probably a sense that the liquidation itself would take longer than a consensual sort of resolution through a plan of reorganization. And I think that some of the belief that the cost associated with the liquidation, in particular, let's say in the Chapter 7 context where there's a trustee, that there would be a steeper learning curve to deal with the liquidation and the claims reconciliation. And so some of us think that trying to engage with the insurance carriers and to come to an agreement to put all the resources into a trust will actually yield more value for everybody. And so that's the direction I think why we're going to. And then there's sort of a more of a technical legal answer also. Because the Boy Scouts are a nonprofit organization, they cannot be forced into a liquidation. The Boy Scouts as a nonprofit sort of control that aspect of their restructuring. And so regardless of how hard we push, we can't push them into liquidation without their agreement. And so I think that those are sort of the two balancing factors. I don't know if you have anything else.
Yeah, I'll just add one more thing. One of a plan of reorganization has to satisfy some minimum standards. And there are about, I think, 17 or 18 different boxes that have to be checked to make sure that a plan can be approved, or we use the word confirmed. But one of them is the following. Creditors are entitled to get under the plan at least what they would get if the Boy Scouts liquidated. So when we look at our demands to the Boy Scouts and the local councils, we are looking at what value could we get for survivors if in fact they went through a Chapter 7 liquidation bankruptcy. That is the floor that creditors are entitled to. And so while there might be a certain personal satisfaction in seeing the Boy Scouts cease functioning for some people, from a economic, financial perspective, if they're not paying what creditors would get in a liquidation, they cannot confirm their plan. And that is something we are laser focused on in our negotiations with all of the parties. Okay, local counsel. So during the New York mediation, we had the opportunity to address our analysis of the local council's assets and liabilities to the entire local council population, those who wanted to dial in. I think we had 725 people attend that Zoom meeting. And I think the lowest number, once we hit that high, was in the very high 600s, because the meeting went on for close to 2 hours. We presented the materials that you will see as an attachment to our disclosure statement objection. We wanted to give the local councils a chance to ask us questions. Our microphone was taken away from us. We were told in fact, I said when I opened the presentation, we will be taking questions, and I was corrected saying, oh no, we're not allowing a Q&A. So if there are local council folks listening who want to know why during that presentation we didn't answer your questions, we were not allowed to see the question. I don't even know if you're allowed to submit questions, We were not allowed to see them. It was a little bit like the old Reagan speech. I paid for this microphone, so it's mine. It was a call set up by BSA, and that was what they imposed on us at the last minute. The next day, I think it was the next day, the ad hoc local council committee responded to our presentation. The audience that we had for our presentation was not reconvened. That was the decision. That was not our decision. We would have welcomed the opportunity for the local councils, people who showed up on that Monday, to hear the ad hoc committee's response, because it was a bit of a dialogue. It wasn't our decision. That's what they did. I would say that we didn't think it was a good response. We thought we gave a very detailed analysis, again, by example, of the local councils, and what we got back were what we thought generalities, and in some cases, information that we thought was simply inaccurate. And I'll just give you one example. It's a big issue in this case as to whether anyone who contributed money or property put conditions on it. We refer to those as donor restrictions. You may only use this campground for this purpose. And if you use it for any other purpose, this is in the deed, then it comes back to us, the donors. So we were presented, we did a detailed review of the restrictions on the local council camps. We looked not only at conservation easements, utility easements, rights of way, but also whether there were these kinds of donor restrictions that would impact the value of the property if we tried to sell it. So one example that was thrown up at us at the response by the ad hoc committee was a campground in Texas. I'm not sure which local council it was. That is supposed to be used to commemorate the Texans who signed the Republic's Declaration of Independence. And they said, see, here's a piece of property that you can't access. Well, if they had bothered to tell us that they were going to use that as an example, they would have seen that in our list of properties that should be contributed, that property was not on the list. Why? Because we read that deed restriction. We understood it was enforceable. We knew it essentially eliminated the market value of the camp for anything other than acting as a memorial to those Texans, and we didn't include it. Yet that was thrown up to us as an example of why our analysis was inaccurate. So just one example that stood out. In fact, every example they gave to us of deed restrictions on property was properties that we did not include in our calculation of what local councils should present. So needless to say, we weren't very happy with the response. And as I said, the dashboards are going out next week through BSA.
Hey, Jim, on the next
go ahead.
topic, these are legal terms. So can you give us the interpretation so folks can understand what some of these motions were?
Sure. John, do you want to take this?
So
It's up to you.
Jim, I'd like you to, just because I've been rifling back, trying answers to questions. And so I haven't been 100% focused, and
Okay,
I
no
missed,
problem.
I missed the cue to me. So I apologize.
That's okay.
Well, at least you're answering questions. Way to go, John.
I've only answered, 76 so far. So
Yeah,
By the way, John and I often know what each other is thinking because we probably speak to each other 7 or 8 times a day.
John is doing yeoman's duty tonight, and I've got a couple main themes I am going to ask you guys about before this is over. Try and capture some.
Okay, I actually think we're a little ahead of our schedule, so it's good. We'll have time. So there are a couple of other matters that are before the judge on May 19th, as I mentioned. The largest, most significant one is the disclosure statement objections. There is a motion by the debtor to extend the time period during which only the debtor, BSA, can file and propose a plan. The Bankruptcy Code sets forth a period of time where only the debtor can propose a plan, and then that period can be extended, not forever, but I think it's a total extension of 18 months, and they're not quite 18 months into this case. We call that concept exclusivity. The debtor has plan exclusivity. So coming out of the Miami mediation, the debtor had filed a motion to extend its plan exclusivity. And we were extremely disappointed with what had happened in Miami. So the TCC filed a motion objecting to the extension of the debtor's plan exclusivity and volunteered in the pleading that the TCC would file its own plan. And there were some significant differences between what, obviously, or else we wouldn't have objected to exclusivity. If we were within spitting distance, we would have tried to work it out, but we weren't even close. A llama couldn't reach in spitting how far apart we were. And so eventually, the coalition joined in our exclusivity objection. And we are working closely with the coalition to see if we can come up with an agreement on the terms of a survivor-sponsored plan. The court knows this. The court can see from the disclosure statement objections that, as one party said, from a survivor's perspective, this plan is dead on arrival. So she will determine whether she's going to open up the process to allow other parties to propose their own plans. Honestly, plan exclusivity is often not a big fight because we're all trying to pull in the same direction. We're on some common themes, and you work with the debtor to try to make it all consensual because it's cheaper that way and it's more efficient and it's faster. We're just not there with them. So at the moment, both the TCC and the coalition are opposing plan exclusivity, asking the court to open up the process so that a survivor-sponsored plan can be presented to you. The second thing that she's going to be considering is what we call estimation. No one really knows how much the claims are worth. I would suspect that none of you, or with very, very minor exceptions, have a judgment against BSA or a local counsel, or have an unpaid settlement agreement. The court, for lots of reasons, needs to understand the value of the claims. And so we have filed with the coalition and the future claims rep a motion for the bankruptcy court to estimate the claims in the aggregate, not how much claimant number one's claim is worth, but in combination, what these 84,000 claims are worth. And we've asked the judge to do it on a couple of different silos by year. So we could let the insurance companies know what their exposure is, by local counsel, so we could talk to the local councils about what their exposure is. And that motion for estimation is before the court on the 19th. Likewise, the Boy Scouts have proposed their approach to estimation. It's different. This meeting probably is not the right forum to explain those differences, but they're different, and they're different in a meaningful way. At the beginning of this, I saw, I did hit the Q&A just to see what was coming in, and I saw someone said, can you tell us about the tiers of abuse? We have published, and it should be on our website, the categories of abuse and the values we ascribe to them. So the categories of abuse are those that were in your proof of claim form. Penetration, oral copulation, masturbation, groping under the clothes, groping over the clothes, and other. I think those are the categories. And we have values for each. These are values that we think represent fair settlements. And it was a combination of I'll probably say over couple of hundred years of experience of the plaintiff's lawyers who work with the TCC and years of experience in dealing with Boy Scout litigation. And so when we talk about the value of the claims, we take each proof of claim form, identify the level of abuse, put it on that claims chart, and we add it up. And then we apply various discounts for factors, including the fact that, sadly, some states are very tough on defenses, not only statute of limitations, but defenses to these claims, and that some will be successful and some won't be. And based on the experience of the plaintiff's lawyers we deal with, we have come to assessments of the overall value of the claims. And that governs our negotiating perspective. So that's estimation, and that's sort of the struggle we have with valuing 84,000 claims. The last is confirmation scheduling. Confirmation is another word for the approval of a reorganization plan. The disclosure statement approval is only a preliminary step to confirmation. As I said, there are, I think, 17 or 18 factors that the court has to find exist before she can confirm the plan. There will be discovery, fact discovery regarding issues that she has to decide. There are a lot of legal issues that the court has to decide. And the Boy Scouts have proposed a schedule for how it will proceed. The Boy Scouts' goal is to have a confirmation hearing at the end of August. I wouldn't bet the farm on that date, but we'll see. We'll see how long it takes to get the disclosure statement approved. But right now, the court has reserved a couple of days, I believe at the end of August, maybe it's a week actually, I just don't remember, for the hearing on confirmation of the plan.
So last,
John? Yeah.
everybody wants to know,
When do I get paid?
when I get paid.
Right. So the answer is, honestly, I don't know. Confirmation of the plan is not really going to trigger a distribution to creditors. And the reason is that we don't have adequate contributions by the local councils, and we certainly don't have adequate contributions from the insurance companies. And so what confirmation of the plan will do is get some money from some sources. I mean, BSA will have to put in some amount of money and some amount of property. It can't skate in the same way that local councils can or chartered organizations, because the Boy Scouts are actually in the bankruptcy. And for them to get out of the Roach Motel, as one judge used to call it, there's a price they have to pay. And we are negotiating with them separately, if they're willing to engage with us, about what it will take from their non-insurance assets, the Norman Rockwell paintings, the oil and gas rights, the Scout University, the headquarters, and cash on hand, how much value we can extract from those sources to allow them to exit the bankruptcy. But that's not going to be enough money to make a meaningful or even an inconsequential distribution, frankly, to 84,000 people whose claims have not been valued yet. I mean, there's a process that has to get employed to do that, and that comes at an expense. So when do I get paid? We are trying with the coalition to put as much pressure as we can on the other sources of money, be it the local councils, the chartered organizations, and the insurance companies. I can't tell you when it's going to be. All I can tell you is that we are as motivated as anyone could be to get you a reasonable amount of money as quickly as possible. And I understand that the amount of money versus the time when you receive it have a relationship. We appreciate, folks, I think I've told you this at the first time, I've been representing sexual abuse survivors in bankruptcy cases since 2004. I know there's an age issue. I know there is a health issue, emotional and physical, and just frankly, especially after COVID, a financial need that is not lost upon any of your representatives, be it John and Doug and the 7 others on the committee or their lawyers. But there is a point at which we say it's not enough. And we're still at that point. So I wish I could give you a better time frame. I just am not able to, and have you have something you could rely on.
Yeah, look, guys, we're fighting and we're doing everything we know how to do. And, but we absolutely will not take less than you deserve. So that's the commitment of the TCC. So John and Doug, I'm going to put you on the spot because we've got like 4 minutes left. Are there any themes in the questions that you have not answered that you'd like to address verbally?
Well, here, I'd like to address one, and this won't be the last time that we talk about it, but it's been raised a number of times. And it sort of goes back to the plan and voting materials about whether or not they're going to be sent to the survivors or they're going to be sent to the law firms. Many people have asked, if the materials are sent to my lawyer, who votes on the plan? And I tried to respond a couple of times, but let me just make clear that it is your decision to vote on the plan. You either vote to accept or you vote to reject. You can consult and get advice from your attorney, and you can inform your attorney on how you want to vote. And so your attorney or law firm should be going to you and asking you how you want to vote. And if the firm is not doing that, then you need to go to them and make it known how you want to vote. This time has not been set. It probably won't be until June or even July of sometime exactly when that deadline happens. And so we will discuss it again, but it is your decision of how to vote, and you need to consult with your attorney and make sure that your attorney understands that.
Hey, John, could you clarify this concept of the master ballot? Because we have objected to it. I'm not sure everybody completely understands it, but even if the master ballot is approved, a survivor has the right to go to his attorney or her attorney and request to vote, correct?
Yes. So, there are roughly 84,000 survivors who are going to have a chance to vote in the plan. That is a lot of ballots. And so the Boy Scouts have tried to make it administratively easier because there are some law firms that represent 10,000 survivors. And so what they want to do is to send one package to that law firm on behalf of the 10,000 people rather than 10,000 packages, and have that law firm work with its 10,000 clients to vote on the plan. The law firm will collect the votes and put it on a list, and all of them will be accept, reject, or exactly how it's going to be to record your vote. And that law firm will send in the master ballot reflecting what your desires are. That's how it is supposed to work.
Okay.
But as I think John was trying to bring out, you should be in touch with your lawyer. And obviously you'll follow our TCC town halls and you'll look at our website from time to time to know that the plan and disclosure statement have gone out to vote. You have to pick up the phone. You have to go to your keyboard and write to your attorney saying, I want to vote on my plan. I want to discuss it with you, or however your law firm's communicating with you, because that's their duty. That is what lawyers are supposed to do. And in fact, the master ballot will have a representation that you have either authorized your attorney to vote for you, or that you have directed them on how to vote. Because some people just say, thank God it's not me, Jim, do what's right. And the lawyer will vote yes or no. But you have the right under every law of every state in this country to direct your attorney what to do. And if you want to have that voice, all you have to do is exercise it.
Okay, we're coming up against 8. Doug, anything to add before we close?
Yeah, just a couple things. First of all, I want to thank John Lucas. John I've answered a handful, but John answered the bulk of 104 questions tonight. We tried to go through as quickly as we could and answer them. We know for some of you, we know that you're frustrated because we couldn't answer your questions, but a lot of them were very individual situations that it's a reason why you need to speak with an attorney. I do want to tell everybody, you can feel the frustration there from some people saying, let's get on with this. The Boy Scouts, the insurance companies are stalling. When is this going to be over? We get this. The 9 of us get this. We've been dealing with what happened to us for decades, and now it's so tantalizingly close to a resolution. We just want you to know that we're working on this as hard as we can, and the attorneys are doing everything in their power to try and push this forward. But a couple themes. One is, Jim, a number of people have asked, what about the Boy Scouts Youth Protection Program and their IV files? Is anything going to be done to address those?
We have in we call these plan term sheets. These are essentially summaries of what our demands are. And our demand in that relation is twofold. One, and I'm not actually sure this has been conveyed to the Boy Scouts formally, but if they're listening, we're doing it now. That they retain an outside professional that the TCC agrees with to review their child protection program and to modify it per the recommendations of the professional. Second, all IV files, rosters, troop, volunteer, camp rosters are turned over to the settlement trust. And that the IV files be published with appropriate redactions in a place that the public can access them. So that is what our demand will be. I think the Boy Scouts, in effect, know that. I'm not sure it's been handed to them in writing yet because we're still trying to finalize other aspects of a plan term sheet with the coalition, but there's no disagreement on those provisions.
And then the last, I think, major theme is a number of people, Jim, have said, can I write the judge? And if so, what's that address? If that's appropriate, is that something we can post?
We can post it on the website. If you go to the Omni site, the court's address is there. If you are represented by counsel, you're supposed to communicate with the court through your lawyers. If you want to write if you're represented by counsel and you want to write to the judge directly, you absolutely should be in touch with your lawyer and consult with him or her about that. I would never advocate that a represented person write to a judge without consultation with their attorney. That would be potentially dangerous to your case. For those of you that aren't represented, if you want to write to the judge, go ahead. What she's doing, I don't know whether she's reading each letter. She did say at one point in the hearing that she is looking at every claim. Now, 84,000 claims. I suspect she is, she said that at a time, by the way, when there weren't 84,000 claims. But Judge Silverstein is dedicated to her job. She is one of the stars of the bankruptcy bench. And I don't think she's listening to this town hall, so I'm not getting any advantage by saying that. I'm sure that if not personally, then through staff, is getting reports as to what these letters say. But just so you know, when she gets a letter, she is sealing it. So when you look at the docket, if you go to Omni, you'll see letter from JS, he doesn't list your name, sealed, which means for that docket entry, if you click on it, nothing happens. Next one is letter from JS redacted. And she has redacted clearly names, and I think some of the graphic descriptions. There's no published standard on how she's doing that. We see the unredacted letters because we're allowed to see the claim forms, and we can see generally what she's doing. But so again, Omni has the court's address, and if it's not on our website, we can post it.
And listen, guys, we're going to wrap it up here, but I just want you to know that as a guy that buried my story for the better part of my adult life and then came out and was able to communicate that to others, it is a cathartic process. I will tell you that beyond a shadow of a doubt. It's probably frustrating when you finally get the courage to write it down, that it gets redacted, but we see it, our professionals see it, we understand what you've been through, and we carry that with us. So with
John,
that,
I'm sorry, can I add one thing? I apologize, and I wish you could have closed with that. We could have closed with that, but there is one thing I was asked to say. We have talked a lot in these meetings about suing local councils. And some people apparently have interpreted that to mean no matter what my claim is, the problems with it, the statute of limitation problems with it, I need to sue. I want to make really clear. If you want to sue, we encourage lawsuits against good lawsuits, enforceable lawsuits. against local councils and chartered organizations. It's how we put pressure on them to come to the table. But consult with a lawyer that's educated about child sexual abuse claims in your state, and be informed as to the merits of your claim. It's just not walking down to the clerk's window and plunking down a complaint. And so I'm sorry, I kind of took the air out of the balloon a little bit by interjecting this after John's comment, but I was asked to make sure people understood that we're talking about merit-based claims.
Thanks,
Sorry,
Jim.
John.
And I have one thing. This
And
is,
the lawyers have just one more thing to say. You guys got to know that's never happened before.
no, but there are so many questions that are coming in that if your question did not get answered, please send your question to BSA survivors at pszjlaw.com.
Yep. We're looking
One
at
more
all.
time, John. John, one more time.
Say that again.
BSA survivors at pszjlaw.com.
It's on the website too. That's posted on the website.
Yeah.
Yeah, tccbsa.com. Hey, listen, man, we appreciate you guys. Hang in there and good luck. We'll be in touch. Good night.
Good night.